Okay. Hi, everybody, and thank you for joining us for our Colorado legislative update. I'm Fancy Petrie. I'm the Director of Client Experience with Goodwin and Company, and I have joined with me your local Colorado leaders. Can you introduce yourselves?
Hi, I'm Ron Cook, the Regional Vice President here in Colorado.
And I am Ange Myers, the Director of Community Associations in Colorado.
Thank you. And we also have with us our presenter, Hal Kyles. Please introduce yourself.
Hi, my name is Hal Kyles. I'm a partner at Orten, Cavanagh, Holmes and Hunt. I've been with the firm for over 15 years, and I'm primarily responsible for managing the collections department.
Thank you, Hal. So today our goal is to get as much information on regarding the new legislative changes, when they'll take effect. And so what we're going to do is just kick things off with a summary of all that's been going on, and then we'll get into a question and answer session. Hal?
Sure. The primary bill that was approved by the state General Assembly and the governor is HB 25-1043. It impacts associations in two or three ways. It makes a couple subtle changes to the notice requirements that associations must deliver with regard to delinquent owners. It also addresses the process of foreclosure when an association initiates foreclosure of its assessment lien. And then finally, it implements some reporting requirements that associations must deliver annually to the Department of Regulatory Agencies here in Colorado. Essentially, when associations renew their membership with the state, they're going to be required to deliver some information, statistics regarding delinquencies.
Okay, and are there also communication requirements that have been put into this bill?
There are some subtle changes to the communication requirements that associations must perform when they're communicating with delinquent homeowners.
So wouldn't this, and just kind of give me your feedback on it, wouldn't this increase the administrative burden for the HOAs, or how does this impact them financially?
Well, I don't know if it'll necessarily increase the administrative burden because these burdens were previously imposed. In 2022, the General Assembly passed a bill, HB 1137, which required associations to communicate with delinquent homeowners in a particular way. Really, it had specifically to do with the method of communication. At the time in 2022, in addition to sending a certified notice to a delinquent owner, associations were also required to actually physically post the notice at the unit. Last year in 2024, the General Assembly removed that obligation for posting, but they substituted other means of communication. Specifically, in addition to sending a certified letter, associations now must attempt communication either with a phone call or an email or a text message. That was imposed last year. Now, this year, they've further modified those methods of communication by requiring that in the event that you're unable to contact an owner either via email or phone, now you have to send the same notice that you sent certified, you have to send that by regular mail. So I would describe the changes not necessarily as imposing a greater burden. The burden was previously imposed. They've just mixed the formula.
Okay. So how frequently do you all have the legislative updates? How frequently are these changes implemented? And how much time is given to make the changes that are being put in place?
So unfortunately, homeowner associations in Colorado have been front and center of the General Assembly's crosshairs for the better part of the last 3 or 4 years. There has been significant legislation that has been approved and become law each of the last 3 years. That process begins in the winter, usually in January when the General Assembly first convenes, and ends at the end of May when the General Assembly adjourns. And so that process, the 2025 General Assembly has now adjourned, and HB 25-1043 was the significant piece of HOA legislation that was approved and signed by the governor.
Okay, so is what's been put in place, is there a space here where it could be abused by homeowners? And if so, are there limitations there to protect it from being abused by them?
Well, unfortunately, I would say, I don't know if I would use the word abused, but it wouldn't be unfair to characterize these changes as a potential for abuse. More than anything, the way that I look at most of the changes specifically that have addressed collection of delinquencies, which is, my area of concern, what these new laws have done is create defenses for homeowners to use against homeowner associations. So it's placing additional requirements on associations to perform specific tasks. The way I described it is in each of the last 3 years, there have been hurdles. Associations have to jump over hurdles in order to legally collect delinquencies. And each time the legislature makes a change, what they've done is raise the hurdle. So now it becomes more difficult to jump over these hurdles, and naturally it creates the opportunity for a homeowner to raise a defense that the association's not complied with the law. So, would I say that there's the opportunity for abuse? It is what it is. It's frequently homeowners don't have a legal defense to a delinquency. There's no legal defense. They simply haven't paid. And that's generally true in 90% of the files or cases that are referred to my office for collection. But if an association doesn't strictly comply with all of the requirements, they didn't deliver notice precisely in the manner that's required, all of a sudden the owner has a defense to delay enforcement. So it doesn't necessarily get owners out of the debt, but it does create the potential for delays.
Okay, so it is very important that we as management company, Good Winning Company, is able to stay ahead of these things and ensure that we put these processes in place almost without any error, because those errors are gaps that they can use to extend, not necessarily drop those costs, but extend the process. And that can actually lead to more costs, I guess, for the association.
I would say that you're absolutely correct in that description. It definitely is imposing a greater burden on associations and obviously through their management companies to adhere to the legal requirements. And it's necessitated that associations here in Colorado, for example, update their collection policy each of the last 3 years. And the passage of 1043 will require that another update to collection policies must be accomplished before the bill becomes effective on October 1 of this year.
Okay, and I know that, go ahead.
I'm just gonna ask Hal if he could kind of give us some main points on the items that need to be updated in that collection policy.
Yeah, absolutely. We just recently finalized our review of the new bill of the law. We reviewed and have made the necessary changes to the formula, to the template that we rely upon, that we use with our clients. So we're now in a position to update collection policies this year. Specifically, the notice provision that I mentioned earlier that now must include sending what I describe as the mandatory notice, right? In Colorado, there is one notice that must be sent to a delinquent owner, and that notice must contain specific items of information. I describe that as the mandatory notice. Ange and Ron are very familiar with what I'm describing. And now, in addition to sending it by certified mail, in the event you're unable to communicate, send the same notice by email or contact a delinquent owner by telephone, then you're also now required to send that same mandatory notice by first-class mail. Now, interestingly, even though this has not been a requirement for the last 3 years, I've consistently counseled clients, associations, that when they send the notice by certified mail, include a copy by regular mail, put a stamp on it, and so even though this is now a new requirement, I think a lot of associations, and Ron and Ange can maybe speak on this, have made it a part of the standard process to also send this letter first-class mail.
Yeah, so true, Hal. I think we've taken the proactive approach. I think we've been sending both the regular letter and the certified letter just to make sure that, in hopes of at least one of them reaching a homeowner that might be delinquent.
Yeah, and that's a good practice. Now they've just codified it. They've put it in the statute and said, well, yeah, it's a good idea to send a first-class letter as well. One of the things that we know statistically is that about half the time, 50% of the time you send a certified letter, an owner actually doesn't receive it. They don't pick it up. It isn't delivered to the unit. It sits at the post office for a few weeks and then it ends up coming back. At least that's my experience when we send certified mail. So, the idea of sending that same notice by regular mail makes complete sense.
Thank you, Hal. Is there any additional information you'd like to give us regarding this bill?
About 1043, well, there is the notice provision that we've discussed. The other couple of significant aspects of this new law have to do with the manner in which an association forecloses its assessment lien. The decision to foreclose is rarely, if ever, made by the association prior to a file being sent to their collection attorney. Almost 100% of the time, any decision or even conversation regarding foreclosure takes place after the file's been sent to my office. We analyze the circumstances and make a foreclosure recommendation if appropriate. Now, prior to filing the foreclosure lawsuit, a notice must come from the association, but bear in mind that notice is coming from me. It's coming from my office. It must be sent not only to the homeowner, but to every party with a recorded interest on the unit. So, for example, if there's a mortgage on the unit, that notice must be sent to the mortgagee, the lender. If any other party has a recorded lien or a judgment, we're now required to communicate with all of those parties regarding the association's intention of foreclosing. That certainly is making life more complicated because we've got, oftentimes, I don't know where these parties are. I don't necessarily have an email for some, Discover Bank or whoever. I may not have a mailing address that's appropriate for a lot of these other interested parties, but that's a burden that mostly falls on my shoulders after the file's been sent to my office.
How long do you have to wait to hear from the mortgage company or second mortgage or?
30 days. It's a 30-day notice. So for the homeowner, specifically the homeowner within that 30-day window can request mediation. Now that's actually not new, Ron. That was implemented last year. The notice that I send, the intent to foreclose notice, must tell the homeowner they have the legal right to request mediation. One of the other new aspects of the foreclosure process, and this is pretty significant, is that after October 1st, when this becomes law, anytime after a foreclosure lawsuit has been filed, but prior to the actual sale of the unit at a foreclosure auction, a homeowner can file a motion with the court asking for a stay. A stay is simply a legal term that means it means stop. It means stop the proceeding. And the specific purpose of the stay is that the owner is indicating that they have an intention to sell the property on their own, in which case the delinquency to the HOA would be paid. But this is another example of a delay tactic, of a delay mechanism. I can start a foreclosure lawsuit and work the file for several months, and then on the eve of actually offering the unit at a foreclosure sale, the homeowner can step in and file this motion. And if it's approved by the court, which unfortunately there are very few guidelines or criteria in this bill that tell the judge how they're supposed to decide whether to approve the stay or not. And so it's my belief that virtually every time a homeowner asks or files this motion, it's going to be granted, as long as the homeowner indicates that the purpose of the motion is that they are going to sell the unit on their own. So they're going to have to demonstrate that they're taking action or steps to do that. The most obvious would be, here's a listing, we're putting it on the MLS, okay? But if the judge approves this request, it's good for 9 months. So it creates a 9-month delay where I'm pretty much hands off. I can't do anything to collect from the owner or to pursue the foreclosure action, as long as the owner probably doesn't need to do anything more than to list the property at a fair market price. That's the other piece of it. Prove that you're actually taking steps to sell it, and that you're asking a fair market price. And the new law essentially gives them 9 months to accomplish that. Yikes. The final piece of this bill, 1043, specifically has to do with the reporting requirements to the Department of Regulatory Agencies. It's the Colorado agency that's managing HOAs and reporting. Homeowner associations have to register annually with DORA, the Department of Regulatory Agencies. Now, after October 1st, on an annual basis, all associations will be required to report the following information. The number of homeowners that at any time in the previous 12 months were 6 or more calendar months delinquent. The number of owners whom the association obtained a legal judgment. The number of payment plans entered into by owners. And when I say payment plans, it would be payment plans that you all at Goodwin established based on the requirement that before you send a file to me, you've got to include in that delinquency notice that I called that mandatory notice. Owners have a right to request a minimum 18-month payment plan. So now you've got to tell Dora every year, how many of these plans did owners actually enter into? And finally, the number of foreclosure actions that were filed against homeowners. Certainly, there's some administrative burdens that are being placed on you all, because this is going to primarily fall on management companies to keep track of this information. So that really summarizes the requirements of 1043.
So can I ask on reporting, what are the penalties for non-compliance with the annual reporting requirement?
That hasn't been established yet. It's likely based on historical, the way that Dora manages this, that there could very likely be some type of civil fine, probably a monetary penalty for failure to comply. That's the way these types of issues have been handled previously. So, but they haven't specified or defined what the penalty would be.
Thank you. Okay,
Hal,
so then, oh, go ahead, Ron.
quick question. Is it up to the discretion of each association to decide when they want to file annually based off maybe when their association registers their association with Dora or
That's
Secretary of State?
Yeah, that's a good question. I mean, I think most associations are probably aware of their deadline, and I actually don't get involved in that process. But I think that you could establish, every association can decide, well, we're going to do this annually in the month of January, or maybe in the months of January or February. And therefore you collate this data that you're required. Maybe you can pick the window, the 12-month window of when you're going to report information. This has been, as you can appreciate, when I've spoken with other management companies, this is probably the aspect of 1043 that gets the most conversation, because it's specifically an item that is going to create a burden on your company to compile this information. Now, specifically information about the number of foreclosure cases, you can get that from the association's attorney, right? Because the attorney is the one that's going to know that and easily have a record of how many foreclosures were filed in the last 12 months. But the number of payment plans, the number of accounts that were at least 6 or more months delinquent, a lot of those files you won't have, you probably didn't necessarily send to the attorney. So that's going to be data that you're going to be responsible for. And so one of the questions I've been asked is a best practice, or how do we go about compiling this, or, especially like Francesco was asking about penalties. The one thing I would certainly say is demonstrate that you have a process in place to comply with the requirement, right? I think that it's less important that you are 100% accurate with your data, as it's certainly much more important that you demonstrate that you have taken steps to comply. Does that make sense? You can't ignore the requirement, so that when any of your clients do register annually with Dora, contemporaneously with that, you're going to have to turn over this data. I think that the association would be opening themselves up for scrutiny or penalty if they just ignored it. So don't ignore it, but it's going to take a while it's a new piece of legislation, and it may take a minute or two to come up with the right processes to compile that information. So.
Is Dora going to have a portal or something that associations report this to, or is it just you're sending the information?
I can't answer that, Ron. I don't know. I would imagine the answer would be yes. I'm fairly certain they're going to try and accommodate the transmission of this information in the easiest way possible. So, simultaneous with updating the DORA registration, are there going to be fields that will permit you to answer these questions? I would imagine that's the case, but that, this information in that portal you're describing is not set up yet. Remember, this law becomes effective after October 1.
All right. Thank you, Hal. Okay, so let's go ahead and get into House Bill 1182.
Okie doke.
Can you provide us with a summary of what this bill contains, implications for the HOAs, and insurance?
Yeah, this primarily has to do with property insurance and risk mitigation for wildfires. The bill implements a map of hazardous areas within the state of Colorado, and there are a variety of zones that are deemed to be more hazardous than others. And so what the bill essentially does is require insurance companies to consider when a homeowner or the association has taken reasonable steps to mitigate fire hazards, which, as most people are aware, there are issues all over the country, but certainly within Colorado. And so if a homeowner or association can demonstrate that they have exercised action to mitigate the risk of wildfires, insurance companies must consider the steps. And obviously the purpose is to try and reduce property insurance coverage and the expense of coverage whenever possible.
Thank you. Did you have anything else to add regarding that bill?
No, I think that's a reasonable summary of what that bill is intended to accomplish.
So what role, if any, can HOAs play in influencing legislation before it becomes law?
Well, that's a really good question. We probably don't have time for that conversation because I could talk about that for quite a while. But I'll give you the 90-second response. It's one of the unfortunate aspects of the new legislation that started back in 2022 with 1137 and 1043 this year. Certainly I don't believe anybody here on this call would describe these new laws as pro HOA. Okay, they're burdensome. They're placing more requirements on what associations must do, and in particular dealing with delinquencies. But it's unfortunate, in my opinion, that the legislation is intended to impact or benefit 1 or 2% of the population of the state, or 1 or 2% of members of any association, to the detriment of 95% of homeowners that pay assessments timely and follow the rules. Okay, and unfortunately, as we all know, the squeaky wheel gets the grease, right? So we have certain legislators within the General Assembly who have an axe to grind, and they've been effective at grinding that axe for the better part of the last 3 years. And what I consistently tell homeowners and managers or any audience that I'm, speaking to, until such time as the 95% of members of homeowners that pay assessments and follow the rules, let their voices talk. Homeowners need to make their assembly members aware of what's happening. These laws are seriously compromising the financial health of associations by shifting the financial burden from non-compliant members to the other members of the association that pay their bills.
Okay, and then to that end, do you have any insight into what additional legislation might be expected to come or what's in the pipeline?
Well, unfortunately, I don't. I had a conversation with Aaron Goodlock, another partner attorney in the firm. Aaron is a member of CLAC, the Colorado Legislative Action Committee, that specifically is the lobbying arm for homeowner associations in Colorado, meaning Aaron has his finger more on the pulse of activity in the General Assembly. And when I asked Aaron this question this morning, Francesca, he kind of chuckled and said, you don't know with this group because anything's possible, okay? If you sort of categorize, or if you take a look and summarize the impact of the bills over the last 3 years, 1137 back in 2022 significantly impacted what management companies were required to change, because mostly had to do with the method and manner of delivery of communication. And then there were some other changes the last couple of years that talked about the foreclosure process and the recovery of legal fees. Now, we really haven't talked anything about that. That was a part of a bill last year that potentially significantly impacts the reimbursability of legal fees when an HOA, undertakes enforcement actions or collection cases. So beyond that, I really don't have an eye for what might come next year.
Well, thank you so much, Hal, for speaking with us today and fleshing these bills out with us.
It's my pleasure.